Lisa, who are all part of the planning committee, who's are working behind the scenes to listen to what folks are asking for and try to make these educational opportunities happen in our community. The next one is going to be a training on harm reduction. It will be on the fourth Thursday in July, probably in the same room if it's as hot as it is right now out there. And for those who don't know, harm reduction is a strategy for reducing harm in our communities. So things that are examples of harm reduction would be wearing a seatbelt while you're driving. That's reducing the harm. Inherently, driving a car is a dangerous thing. If you wear a seatbelt, you have less risk of your own life. In drug treatment, harm reduction is sort of a theory of if we reduce the harm, people may live longer and healthier lives. So if someone is trying to quit smoking, it might be a more achievable goal to go from 2 packs to 1 pack a day, right? That's reducing the harm of smoking, and then maybe we can continue to move down. So it's gonna be a great training. Hopefully you'll be there. Same time, same place. Today, we are super grateful that Joe Strain has donated his time and energy to come and talk to us. Joe is an attorney who lives in the area, practices in the field of criminal defense, but also has a new job doing some more civil stuff, but has a lot of experience in the world of criminal defense and has been prepared with some of the questions that have come out of our previous meetings about how does the criminal legal system work, why are we seeing this catch and release happen in our community? What do we mean by due process, this word that we keep hearing being thrown around in immigration context, in the context of the criminal system? But he's also, after he shares some of his thoughts and answers to those questions, he's going to take questions from the group as well. So thank you for being here, Joe. Yeah.
So I'd like to start off just with a story from my own life. In 2010, I was arrested and charged with a DUI in Delaware County, Ohio. In between college and law school, I had started working in the restaurant and bar industry. And after the bar that I was working at closed, we had a couple drinks. And I left to drive home, and in front of me, and sped up a little to get through the yellow light rather than the red. Little did I know, a sheriff's deputy was heading the other direction, turned around, got me with his blue lights, and I was arrested. I just to a breathful, was told I was providing an insufficient sample of my breath, and was charged with DUI refusal. Truth is, I may not have been trying that hard. I was fortunate because my family had resources. And so I was able to hire a private attorney, a gentleman who was very well thought of in my community, to represent me. I paid him $4,000 to represent me on a DUI-1, having never been in trouble before. We met once at his house. I noticed the Ferrari sitting in his driveway. And he asked me a bunch of questions about the case, and I never heard from him again. I called probably once or twice a week for a period of 5 months, and never got a response. My first hearing was an arraignment at which he sent one of his associates, who was 1 year out of law school. Same gentleman showed up to the status conference, which was the second hearing. The attorney that I hired, I heard from the next time when I was at my pretrial conference about 4 months later. At that hearing, we learned for the first time that the police officer who had arrested me had been fired for lying about another traffic stop. So we used that opportunity to plea the case down to a reckless operation, and the state initially wanted a $1,000 fine. I told him I paid you $4,000, lower that fine for me, and he did. He got it down to a $300 fine. And the reason why I tell you this is because, first of all, it's important to recognize the fact that people make mistakes, and you're not defined by the dumbest thing that you've ever done in your life. And the second reason why I tell you that, why I tell you this story, is because criminal defendants come from all walks of life. I was a college-educated young man who had a bright future in front of him, who's now a licensed attorney. And that may not have happened if I came from a different walk of life. So I bring this story to your awareness for that purpose. I want to lay a few ground rules before we get started. So as a practicing attorney, I have some ethical obligations, one of which is can't tell you about my cases. I appreciate the fact that people find cases interesting, but I am the guardian of many of your neighbors' secrets, and as a result, I'm not able to get into the details of individual cases. I'm happy to talk through hypotheticals, and I'm happy to give you what I think about the law. Second thing, I'm not going to talk about policy. I'm not a lawmaker. I have not been elected to anything, so it's not my job to determine what the policy should be in terms of the criminal justice system in the state of Vermont. The reason why I've been asked here is to help explain to you how the process works, and you may get a little bit of hints in terms of where I think that things don't necessarily work well, but it's not my job to tell you how to fix them. That's somebody else's job. I'm also not a policy expert, so I'm a practicing lawyer. Last thing is, this is not a TED Talk. Feel free to ask questions. Feel free to interrupt with questions. If you have questions about what I'm saying, let's get them out and we can all talk about them. This is part of the conversation series, after all. So Owen provided me with some primer questions. The first one is a doozy, which is, how does the criminal process work in the state of Vermont? I could talk for 3 hours about that. So my thought is to walk through a few things in terms of from the time that an investigation starts all the way up until sentencing in jail. It's a little bit of a different forum than I anticipated we were going to do this in. So I'm not going to do some of the things that I was planning on doing, but I'm going to walk you through. So most of the time, a criminal investigation starts one of two ways. Either a police officer has eyes on somebody who they identify as having committed a violation of the law, or it comes from a report from a civilian witness. So the first one is usually in the case of either the police officer knows this person, knows they're subject to certain conditions of release, conditions of probation, etc., sees them in violation of those conditions, and chooses to respond to that. Or it's a traffic violation in which the police officer sees someone commit a traffic violation, approaches the vehicle, and then broadens the investigation after that. In the state of Vermont, in the second case, which is what we call a VCVC, or Vermont civil violation, there's a statute, there's a law that says that they're not allowed to expand the stop beyond the time that's necessary for the person to identify themselves and provide the relevant paperwork. That is not typically happening on the ground. So oftentimes, while someone is providing the relevant paperwork, they're asking additional questions to try and form the basis of probable cause, or at least a reasonable suspicion to get them out of the vehicle, usually in the case of a DUI stop. The Vermont Constitution is more restrictive than the United States Constitution is in terms of police action, in terms of search and seizure law. So the Vermont Supreme Court has regularly decided that in order for police officers to conduct additional investigations, they have to do things beyond what just the United States Constitution would require. And the big one that we point to as criminal defense attorneys all the time is a case called State v. Sprague, which requires them to have specific articulable facts to get someone out of a car for a DUI standardized field sobriety test. So that's how an investigation generally starts, is in one of those two ways. A few other things that are really important to know. Obviously, you're all subject to both Fourth Amendment protections, meaning protections in terms of search and seizure. Police need warrants to arrest you at your house. They need warrants to search your property. You're under no legal obligation to consent to those things. Consent to those things. If they get a warrant, you can't stop them, but you also don't have to say, yes, I consent to the search, okay? Does anybody have any questions about the investigative process? Another thing we should probably talk about is self-incrimination, but.
Well,
Yeah.
People can call and report something, right?
So that really comes in two forms. The first is a witness who's willing to identify themselves. That person is going to be given more credibility in terms of the court determination whether or not there's probable cause for additional investigative steps than an anonymous tip. An anonymous tip can form the basis of them starting an investigation, but if there aren't corroborating facts, the court's going to look less favorably upon additional.
My experience as an early childhood education, running the child care center in South Wales, I had two incidents that were mandatory to report. So in the 1980s, I had to report to domestic violence.
Yeah, so mandatory reporters are common across healthcare providers, education providers, and certain other protected professionals. So if you're talking to one of those people and you report, particularly domestic violence towards children, those are going to need to be reported to police for that person for their licensure purposes. It's also important to talk about self-incrimination. So the right against self-incrimination, you're not required to answer questions from police. They are not required to advise you of your rights to remain silent unless you are under arrest and subject to interrogation. So if you are under arrest and they're trying to ask you questions about the allegations, then they have to read you your rights. Most people from TV think that the moment they put you in handcuffs, they have to read your rights. That is not the case. So in terms of additional steps in the investigative process, does anybody have any questions? Ed? Dave, I'm sorry.
Repeat it for the sake of Orca.
Absolutely.
And then if anybody has any cell phones that are still on, if you could silence them, that'd be awesome.
Are there law enforcement officers who do not need to have a warrant to search a car?
So really that would only be at the border. Oh, I'm sorry, right. So the question was, are there law enforcement officers that do not require a warrant to search your car? So there are exceptions to the warrant requirement in certain circumstances. Those include exigent circumstances. So for instance, the one that you see commonly is in terms of drug cases. If someone is passed out behind the wheel of the car and they believe they're having a health crisis, they will take the person out of the vehicle. That doesn't allow them the ability to search it beyond that health crisis in order to get the person out. At the border, there's a limited amount of a privacy interest. So because you're coming across the border and within a certain limited area across the border, there's a limited privacy interest. Other than that, it's your constitutional right, and the police officers are subject to it. So there are no specific designated police officers who can search your car without a warrant. And I'm sorry, go ahead, Dave.
I grew up where, back on the hill in the farm, we were told that the game warden stopped. You could demand to look in your vehicle.
Yeah, not true.
Now you are.
So the question was, he was told that a game warden was allowed to search your vehicle without a warrant. That's not true. They're still subject to the constitutional requirements, just like any other law enforcement agency. Just to be clear, game wardens are fully licensed law enforcement officers in the state of Vermont. Yes.
With the investigation piece, can you speak to some of the things we've seen in Bethel with like longer term drug bust investigations and how that might be different?
Sure. So the question was, in terms of the investigative piece, can I talk a little bit about the more long-term investigations that we've had, particularly with regards to drugs in Bethel? I'm going to loop back because I wanted to finish answering Dave's question real fast. That's all right. So there are other exceptions to the warrant requirement that could apply in vehicle searches. One of them is an inventory search that is not valid in the state of Vermont. That's one of the things that the police office or that the Vermont Supreme Court has said does not apply in the state of Vermont. So absent exigent circumstance, so essentially an inventory search would be in a lot of states, if they arrest you and they're seizing your car, they can do a search of the car in order to create an inventory of the car to show what all's in it, so that when you get the car back, you can't say, oh, I had $1,000 in there and the police officer stole it, because they're doing an inventory of it at the time that the car is seized. Can't do that in the state of Vermont. In the state of Vermont, they have the ability to seal the car, apply for a warrant for a search, and seize it for a reasonable amount of time in order to do that. But they cannot just go into your car because you're under arrest and search the car. I have seen it happen, but they're not allowed to do that. Back to the long-term investigations. So we all know about at least a couple of major drug busts in Bethel. There is a task force called the Vermont Drug Task Force that is comprised of both the Vermont State Police, the FBI, and the ATF. They have designated prosecutors at both the federal and state level. They are the ones who primarily do long-term drug-related investigations. And they piece them together all throughout the state and all throughout the country. So they're very sophisticated investigations that take a significant amount of time and effort beyond what most local police departments can actually do. That's all I can really say about those two cases. So there are qualified law enforcement officers who are doing significant drug investigations in central Vermont right now. And they are, my understanding is that there was a very significant drug bust in White River Junction over the weekend. I know very little detail about that case other than the fact that it sounds like a very significant amount of drugs and guns were seized. A very significant amount of drugs and guns were seized. The Vermont Drug Task Force. And I'm sorry, give me one moment. The Vermont Drug Task Force, former, soon to be retiring Vermont Supreme Court Justice Karen Carroll was the designated prosecutor at one point. They have highly qualified prosecutors and usually secure convictions in the cases that they investigate. Not a hard and fast rule, but they do a very thorough job. Yes. Yep. Mm-hmm.
Today, but I'm wondering whether there have been a number of cases recently in Vermont, and I know in lots of other places in the country, where searches and seizures of people who are suspected of being undocumented are bad. And the trainings that I've had, and I know some other people have always said that there needs to be a judicial warrant presented before that person can be grabbed. It seems that that has not been happening. I'm wondering if federal process overrides Vermont warrant law, or what happens when there's a conflict between federal practice and the Vermont law?
So the question was twofold. First of all, in terms of people who are suspected of being undocumented here, what process applies to those folks in terms of seizure of them off the streets without a warrant? Second question is whether or not Vermont law can set a higher ceiling in terms of arrest by federal agents. So the answer is that there has to be, just like anybody else, undocumented people enjoy all the same constitutional rights that anyone in this room does. So there needs to be probable cause in order for them to be arrested. That's not to say that they're not arrested without probable cause, but if they are, they're arrested unlawfully. And that can happen. Not legally, but that can happen. Second question is whether or not Vermont law sets a higher ceiling. It does for Vermont law enforcement personnel. It does not for federal law enforcement personnel. So the federal law enforcement does not need to necessarily abide by Vermont constitutional law or Vermont statutes. And there is a pretty famous case that's going on right now in Brattleboro where the FBI was not abiding by a federal statute and provided information to the Vermont State Police that was taken in contrary to the Vermont Constitution and Vermont statute. And the question that's going to be eventually before the Vermont Supreme Court in that case is whether or not they can hand that evidence over to the Vermont State Police when it was initially, detected by federal law enforcement.
So the ICE people come in, federal ICE people come in and grab people in Vermont.
Right. Yeah, Vermont is not empowered under the federal constitution to regulate the borders. The borders. Oh, I'm sorry. And the question was if people if ICE comes into Vermont to seize people, can they do that? And the answer is yes. There's not a whole lot Vermont can do about that. Any other questions about the investigative piece? So I've got a couple of defense tips for you in case you find yourself being investigated for a crime. So, and both of these are part of the investigative piece. So in the state of Vermont, there are several cases or several charges that are associated with things in the slightest degree. They are, amongst other things, DUIs and domestic assaults, or really any assaultive conduct. So if a police officer asks you on a scale of 0 to 10, how much are you feeling the effects of alcohol while you are under investigation, you are under no obligation to answer that question to begin with. And beyond that, the only right answer is 0, or else you're getting put in handcuffs. Slightest degree, 0.1, you're getting put in handcuffs. So there is a Vermont Supreme Court case indicating that it is not a crime to deny unlawful conduct to the police. You cannot be charged with false information to a law enforcement officer for saying 0 out of 10 if you are being investigated for that purpose. Second one is assaultive conduct. Pain in the slightest degree. One of the things that police officers will ask people when there's any sort of allegation of physical conduct or physical contact between two people throughout the course of an argument is, did they put any sort of hands on you? And on a scale of 0 to 10, with 0 being no pain at all and 10 being the worst pain you've ever felt in your life, how much pain are you in? And many people, out of the desire to not feel stupid, will say a 1 or a 2, when later they tell me, I didn't actually feel any pain. I just felt stupid having called the police saying that it was a 0. This is different than the DUI thing that I just said, in the sense that you can't give false information to law enforcement officers to cover for somebody else. So you can't lie to them and say, I felt a 0 when you felt a 5. You could, in theory, be charged with a criminal act for that, which is false information to law enforcement officers. It's a misdemeanor charge. I, in practice, have never seen anybody actually charge that from a prosecutor's office, but it is something that in theory could be charged. So I can't give you advice to say 0, but what I can tell you is you don't have to talk to police officers. If you say anything other than 0, or I'm not answering that question, there's the possibility that the person who is on the other side of the equation is going to end up in handcuffs, and they will if you say any other number. So those are 2 pieces of advice from a defense attorney. Any other questions about the investigative piece? Okay. So once an investigation concludes, and investigations can last sometimes months or years, depending on the nature of the offense. Sometimes it's the investigation starts and you're cited for a hearing within hours. In the cases of really complex things like homicides or sexual assault cases, it could take years for the police to investigate an offense. But once the police officer has reached a determination whether or not there's probable cause to charge you with an offense, the police officer is going to write up what's called an affidavit of probable cause, which is essentially just a document that says, these are the steps that I took in my investigation. These are my observations or the things people told me. And based on this, I think the elements of the crime are met. That is subject to several layers of review. So it's first sent to the state's attorney's office. State's attorney's office decides whether or not there's probable cause for a charge and whether or not they're going to charge the offense. They also have the ability to refer it to diversion. I know there's going to be another one of this series on diversion. So they can send it off to diversion, or they, in many cases, will end up charging cases. Then there's a second layer of review, which is by the judge, the presiding judge, usually within the few days before an arraignment, which we're going to get into what an arraignment means here in a minute. The judge will make a determination as to whether or not the probable cause standard is met. And the probable cause standard to charge someone with a crime in the state is simply whether or not there is enough information to make up the elements of the offenses. It doesn't even have to be information that's more likely than not. It just has to be whether or not there's enough information that a reasonable fact finder might rely on in order to charge the offense. So really the only way that a judge and a prosecutor are not finding probable cause for a charge is if there's a hole in the case. So every crime is made up of essential elements, things that the state has to prove existed at the same time in order for a charge to exist. Yes. Yep. And it's not squishy. It's every person has a due process right to notice as to what a criminal offense is. So these are things that are very clearly established in the law as to the state has to meet these certain things in order to prove a case. And I'm going to keep on using a DUI as an example, not only because it's the second most common offense in the state of Vermont, but also because it's one that everyone's fairly familiar with in terms of cases. The first is a violation of conditions of release. And we're going to get into conditions of release here in a minute, and I have some opinions about that. So the elements of a DUI are that a person operated a motor vehicle on a public highway while under the influence of alcohol and while impaired to the slightest degree. There's also a DUI legal limit in which the last section or the last element is changed to above a 0.08. Many people think that if you're below a 0.08 that you're not DUI. In the state of Vermont, if it's a 0.1 on the 10-point scale, you are potentially guilty of a DUI. So the state has to prove that each of those elements existed at the same time in order for there to be probable cause for an offense. What if you operated a motor vehicle and then got home and chugged a 6-pack of beer? Can the state prove that? I've had that case, and the answer is probably not. So the state has to prove each of those essential elements, and they have to have enough information that a reasonable person would rely on it in order for there to be probable cause. So at the time that the police officer makes a determination that they have probable cause for an arrest, they issue a citation. That citation is for a future court date called an arraignment. That arraignment is the preliminary hearing in the case, which gets the case started. That's my phone. So does anybody have any questions about the probable cause standard and the charging decisions? Okay. So the arraignment is going to be the subject of, I think, a bit of discussion here, because it's where we talk about bail and it's where we talk about conditions of release. It's also important to note that when the police officer makes a determination whether or not there's probable cause. Some of those people are going to jail at that time and they're having an arraignment in the morning or the next business day. Usually those are cases that involve crimes of violence or people with very significant records that are going to get held overnight. It's usually not your misdemeanor DUI one. It's usually not, a retail theft or something like that. Those folks are called flash sites. They have a right to be heard within 1 business day. They can invoke a rule called the 24-hour rule and if they want to come to court or think about their decision as to what they want to plea. But the arraignment is a very pro forma hearing. It just gets the process started. It's where we enter a person's plea and we talk about bail and conditions. So the state is required to present the defense attorney with the information that they have at that point, which is usually just the affidavit of probable cause as well as any supporting documents and criminal background checks, because those are going to be really important in terms of whether or not the person gets out of jail that day. So one of the questions that Owen sent me is about catch and release. And the arraignment is the time where people walk out of the courtroom that maybe some people think they shouldn't. And a lot of that has to do with both the constitutional and statutory scheme in the state of Vermont. So when we're doing arraignment, there's really 2 things that are at issue. The first thing is whether or not the person is going to have bail imposed, could also be potentially held without bail in certain circumstances, and I'm going to get into those. And then whether or not conditions of release are going to be imposed and what those are going to look like. And those conditions are kind of the rules of the road while the case is pending to make sure that everybody's safe, both on the street and that the defendant themselves is safe. So Vermont law really treats criminal cases in 3 buckets. And I'm going to do something that I thought I wasn't going to do, but can I get 3 volunteers? It is Martine, Nancy, and I'm going to take up Owen's time. Can I get you all 3 of you to stand up? Sneak over here.
Are we being identified in the lineup?
No, 3 of you are standing up right here.
I feel like
So
something not right.
You have to get in the middle.
So there are.
Oh, no. I was gonna put you-
So there are really 3 buckets in the state of Vermont in terms of our law. And the reason behind it is the Constitution. Ever since the beginning in the state of Vermont, there's been a presumption of release for everyone that was not charged with a capital crime. And the capital crime portion of the Constitution has also been now interpreted to represent people who are charged with offenses punishable by up to life imprisonment. So Owen, you're charged with murder. You have no criminal background whatsoever. There are mitigating circumstances. You may have acted in self-defense, but you're charged with murder. There is going to be a presumption in the state of Vermont that Owen is held without bail until such time as we can have a second subsequent hearing at which the state's going to have to put on evidence. It's a presumption. It doesn't always hold fast and true. The court does have the ability to release that person, but it is incredibly rare that someone who's charged with a life offense is going to be released on bail or conditions. The life offenses are really homicides, sexual assaults, or people who are charged under the habitual offender statute. And the habitual offender statute is essentially anybody who has 4 prior felony convictions and is facing a subsequent felony, regardless of what those felony convictions look like. They could be non-violent offenses, they could be misdemeanors. There is also, I'm sorry, they can't be misdemeanors. That's where I tripped myself up. They could be non-violent offenses. They could be things in which nobody else got hurt. But if you are charged with a life offense, which includes being a habitual offender, there's a presumption that you are going to be held without bail until a hearing that will usually happen 1 to 2 weeks later. That can be incredibly disruptive to people's lives, but because of the seriousness of the offense, there's a presumption that you're not going to stick around to be prosecuted when you're facing life in jail. There's also a presumption that you're not going to be a safe person who's out in the public if you're charged with something that's serious. So it's a very high and heavy burden to get that person out at that stage, okay? So Owen's staying in jail. Go back to jail, Owen. All right, I'm sorry, one more time. Nancy. So Nancy is charged with a felony crime of violence. We'll say it's assault. We'll say it's assault and robbery. Nancy has no prior criminal background, but she has a history of, we'll say, traffic tickets and no substantial ties to the community. She's not from Vermont. She just came up here to commit her assault and robbery and head on back down to New York. In Nancy's case as well, there's a presumption that she's going to get held without bail. The Vermont Constitution was amended in the 70s so that people who are charged with a felony crime of violence like Nancy can be held without bail. It was a constitutional amendment process. It's been interpreted by the legislature more broadly than I think it merits. It requires a felony crime of violence against a person. So the legislature, I'm sorry, Kurt, passed a statute recently that if you have possession of a firearm while committing another felony, that can be considered a felony crime of violence. I don't think it can be considered a felony crime of violence against another person, so I don't think it's subject to the determination as to whether or not Nancy can be held without bail. That being said, Nancy can only be held without bail for 60 days. Unlike Owen, who can be held without bail indefinitely, Nancy can be held without bail for 60 days. The state has to bring her to trial in 60 days. If the state cannot bring her to trial in 60 days, which was often the case during COVID, Nancy gets bail. And bail is monetary, is essentially money that you put forward to the court to guarantee that you're going to show back up to court. After 60 days, Nancy gets bail. By law, she is required, it's part of the Vermont Constitution that Nancy gets bail. But Nancy has no ties to the community, so we think Nancy might be a bit of a flight risk, right? She also has no criminal history, so the court's going to weigh that in terms of whether or not Nancy's released, because that character of not being a criminal is going to weigh in favor of Nancy, not being a danger to the community. So Nancy, the court can set any amount of bail that it believes to be reasonable, but the court can only set bail in the state of Vermont not to protect the public, but only to mitigate the risk of flight from prosecution. So all we really care about after that 60 days in terms of getting Nancy out is whether or not she's going to show back up. And the court may, in Nancy's case, because she's from out of state, impose bail, but my guess is I'm getting her out on conditions. So you're out on conditions, Nancy, you can go sit down. Third case, you are charged with either a felony that is not a crime of violence, Martine, or you are charged with a misdemeanor. In either case, you are not allowed to be held without bail. The Vermont Constitution makes you bailable from day one. From the arraignment, you're getting out, if you got somebody who can put up the money. What the court will do, almost certainly, regardless of the charge, is impose some amount of conditions. And those conditions of release could be things like you can't talk to your family members. Could be things like you're not, let's say I'm sure with the name like Martini, they might impose something that you're not allowed to consume alcohol. Which may be a problem for some members of the community. Until recently, they were regularly imposing conditions that required people with serious substance abuse issues to not own, possess, or purchase or consume any regulated drug without a prescription. You can imagine what kind of havoc that could play on somebody if they have a serious drug addiction. Oftentimes, people are told over the will of the person who they allegedly assaulted, that they're not allowed to be in contact with that person. The court will impose those conditions in order to protect the public. But Martine, you're getting out day one if you have somebody who can put up the bail, because that's what the Vermont Constitution requires. And the judge doesn't have the discretion to hold her without bail. The amount of bail depends on the type of charge. So there are some charges that are what are called predicate offenses, And those are offenses that can form, if you're convicted, can form the basis of a heightened penalty. Those cases can be used, they can impose bail in any amount that's required for you to come back to court, but only for that reason. And by the way, Vermont is different in terms of that. The legislature actually did a good job on this one. And throughout many other jurisdictions in the United States, they can hold someone on bail to protect the public. They can't do that in Vermont. It is only for the purposes of making sure you come back to mitigate the risk of flight from prosecution. So you're getting out. Get out.
So you can go see your
Mhm.
what's the process of bail if it's domestic violence?
So a domestic assault case is a predicate offense. It depends on a number of different things, whether it's charged as a felony. If the person has a prior domestic assault charge, then it's a felony. If the alleged victim, you'll hear me use the word complainant or alleged victim sometimes. We as attorneys, particularly criminal defense attorneys, are trained not to use the word victim. We're actually not allowed to use it in front of a jury in the state of Vermont because it's really an accusation that's up for the jury to determine. And by using that word, you're predetermining that a crime has occurred. So if the alleged victim has an order of protection, so that would be an RFA or potentially conditions of release preventing them from being in contact with them, and then the person commits a crime of domestic assault, that is also a felony crime of violence. And then also it could be, depending on the nature of the crime, of the violent act itself, it could be a felony crime of violence. So if there's an allegation of strangulation, the impairment of any sort of bodily function, or if there's serious bodily injury resulting, then that could raise it to the level of a felony crime of violence, which is going to be our middle case, where the person can be held without bail for up to 60 days. The Nancy case, yes. So that's Nancy's boat. In reality, in terms of many of those cases, the next subsequent hearing is going to be what's called a weight of the evidence hearing. And that's where the state is going to have to put on evidence to demonstrate that that first of all, that the evidence of guilt is great, and that's a legal standard, which essentially is just like the probable cause standard that I talked about. It sounds like it's a really high legal standard to hold someone in jail, but it's essentially whether or not each of those essential elements are met based on affidavit or based on live testimony. Sworn statements have to be sworn statements, which is a little bit higher than the probable cause standard because the probable cause standard can be based on hearsay. So they can be held without bail until that preliminary hearing, at which they have to demonstrate that the evidence of guilt is great, that they're charged with a felony crime of violence, and that no condition or combination of conditions can reasonably protect the public. And that's where a good defense attorney with the right defendant can usually make a case for someone to get out of jail. Because if they have a demonstrated record of complying with court orders, there's going to be a presumption that they're going to abide by the conditions of release that the court will craft, which could include things like a 24-hour curfew. So they'll be, stuck at home moving forward. Denise.
Are all domestic violence cases felonies or some misdemeanors?
No, many of them are misdemeanors. They are most commonly misdemeanors. And most of the time, the first one is going to be charged as a misdemeanor unless there's one of those aggravating factors that I talked about.
What does a misdemeanor mean?
Good question. So a misdemeanor is any crime that is punishable by less than 2 years in prison. So if there's a max number above 2 years, then it's a felony. There are no grades of misdemeanors and felonies in the state of Vermont. There are no classes. In New Hampshire, they have classes, but in Vermont, it's a felony, or the Sentencing Commission has thought about changing that, though. Gene.
Emotional abuse. Is that assault?
It would not be considered assault under the Vermont statutes. It could be considered abuse under the relief from abuse statutes. That definition was broadened, I think, in the past year or two, to include things like isolating people from family members and prolonged emotional abuse. So, not considered assault. Could make up the basis of other potential charges, depending on the nature of the conduct, but not assaultive. Yeah, yeah. Owen.
I think a question that people had in some of our neighborhood conversations in October was, if we see someone who's a known dealer
Mhm.
who has not returned for court dates, like
Mhm.
warrants out
Mhm.
for non-appearance, and then they get arrested and then they're released again,
Mhm.
how does that happen? Where if someone has a track record of not coming back to court, they still get out? Is that because of what you just explained?
Good lawyering. I don't know what to tell you. So I think in most cases, judges are going to give people chances. They're going to give people the opportunity to, if they're not charged with one of those hold without bail crimes. Second thing is, you got to remember, if they're only charged with misdemeanors and they're on an arrest warrant for a misdemeanor, particularly a non-predicate offense misdemeanor, maximum amount of bail that a judge can impose is $200. If you know somebody with $200 who can come get you out of jail, then you're getting out on the street. And that's what the law says. That's not what the judge's discretion says, the prosecutors, the police. That's just what the law says right now. I'm going to sit back down so I feel a little less.
Question about
Yes.
bail.
Yep.
So how does, you just said something about the maximum could be $200 for certain situations.
Yep.
But how does the judge determine that, or does the judge have some freedom in having a higher bail versus a lower one in certain situations?
So the question was, how does a judge determine whether or not an offense is eligible for the $200 cap, and whether or not how the judge goes about determining that? The answer is, it's written in the law. There's a statutory scheme that I can't say that I totally understand, and I will be honest when I don't necessarily know things. There are predicate offenses and felonies are eligible for any amount of bail. And that's, again, a predicate offense is a crime that if you're convicted of future similar conduct, there is a heightened penalty for it. So that would be things like DUIs, where if you get a DUI too, then you're looking at a heightened penalty, okay? So those are subject to a limit that's above a $200 limit, as well as felony cases the judge can impose any amount of monetary bail. Misdemeanors, so not punishable by over 2 years, that do not form the basis of a predicate offense, the maximum amount of bail that's eligible to be imposed under the law is $200. I think with some limited exceptions. I don't know if you know the answer to that.
Has that number been the same for a long, long time?
No, I think that's actually a fairly recent development. I believe that happened in, I want to say like 2017. And there's been some discussion of rolling that back.
Rolling the limit back, or like just getting rid of the $200 bail?
Either, well, I'm sure there's been discussion of both. There's kind of there was a general consensus a few years ago that people shouldn't be jailed because they don't have the money to get out of jail. So when I said I wasn't going to talk about policy, but that being said, I think that there's also a fair amount of pushback at this point, particularly in certain communities where they've observed this catch and release phenomenon. There's been a certain amount of pushback from members of those communities in terms of these people, getting right back out on the street the next day. So I think it goes both ways in terms of the discussion. Okay. Gene.
What you're saying is that the catch and release is not necessarily related to backlog in the legal system.
Correct. I would say that it has very little to do with backlog in the legal system. I will say that there are a significant number of pretrial detainees in the state of Vermont that does have to do with the backlog in the legal system. Well, I guess this is the way that you could tie it to it. There are a significant number of pretrial detainees in those first two buckets, either the felony crimes of violence or people punishable by life imprisonment, that are taking up beds in correctional facilities. And as a result of those people taking up beds, there's kind of a hesitancy to continue to overload the Department of Corrections in terms of people who are committing low-level misdemeanors being incarcerated as a result of stealing food from the co-op. Okay? So that's kind of the catch and release and the bail and conditions portion of the process. Does anybody else have any questions about that? No. Yes. Yep.
I'm just thinking about situations where people have been, or maybe a certain characters in our town have been arrested multiple times for drug possession. So it's not a one-off, it's multiple times, yet they're constantly released. Does not this situation ramp them up to reasons to hold them longer or to have a higher bail? Or
So one of the factors that the court looks at in terms of, I'm sorry, yeah, I got to get used to that. The question was whether or not people who have been released multiple times and have multiple pending charges, whether or not those charges mounting is something that can cause a higher bail number, essentially. So one of the factors that the court can look to in order to determine that risk of flight from prosecution factor, all those factors are laid out in a statute called 13 VSA 7554. And they look at the character of the accused as well as the number of charges. And I think that weighs in terms of both of those factors. So if you're picking up a bunch of charges, picking up more charges, picking up more charges, picking up more charges, that speaks to both the character of the accused as well as their risk of flight, because as you're picking up more charges, there's a higher likelihood of incarceration once you're convicted. And many judges, once that starts happening over and over again, will use that as the opportunity to either impose some amount of monetary bail or impose an amount that's going to really sort of ratchet down the behavior, which probably isn't legal because, again, monetary bail is only allowed to be imposed for the purposes of mitigating the risk of flight from prosecution. It's not to hold somebody in jail so that they can sit there until they're convicted. It's just to make sure that it's the amount of money that's required for them to come back to court.
I guess I never thought of it this way, that every time somebody gets caught and released, they have an indictment against them and things are mounting. At some point in the future, they're going to have a court hearing.
Yes.
Right? And then then something will come of that. So when they are released, it doesn't mean that they're just gotten a slap on the wrist. They're just waiting for their time in court.
Right.
How much time does that usually take from the time? Is there?
That's where we're going next.
That's a bad.
And is it cap on bail when you've got mounting charges? Is there a cap on that?
They can impose it consecutively, meaning that they could impose it for each case. They could impose $200 for each case. In reality, that doesn't happen very often, but they could, in theory, do that. Also important to know is that while we do have the constitutional right to bail in the state of Vermont, there is a statute that allows for that to be revoked if you're doing things like obstructing justice or doing crazy stuff certain crazy things on the outside. Just violating your conditions of release is not enough. Just talking to your alleged victim isn't not enough. But if you are obstructing the judicial process, the court has the inherent authority to throw you back in jail. So if you're out there busy, harassing witnesses and threatening people, they can put you back in jail, and that's going to be a hold without bail, just like you were punishable by up to life in prison. Denise.
So some of the cases in town the last several months, some of them had $25,000 bail. Did they have to come
So, well, let me repeat the question first. So the first question is people who have bail imposed, do they have to come up with the whole number? And the example was 25,000. The question is, how could it possibly be 25,000 under the circumstances that I named? I'm going to deal with the second question first. So the second question, remember, there are cases that are not limited by the $200 limit. The predicate offenses that subsequent offenses are punishable by additional punishment don't fall under the $200 limit, and felonies don't fall under the $200 limit. So if you're charged with a felony drug possession case, then they could impose whatever amount of bail that the judge thinks, based on the argument of the attorneys and the evidence presented to them, is going to be the number that's required to get you back to court. So that number could be, I've seen cases where they've imposed bail in the six-figure range. And usually those are incredibly serious cases, but it's within the statutory and constitutional framework that they can do that. Second question is from Denise. Do they have to come up with that $25,000? The answer is no. There are bail bondsmen who will, if you put up 10%, bail bondsman keeps the 10%, but they're going to put up the rest of it for you. And I've seen it before, if you skedaddle, they're going to come find you because they want their bail money back. It's not quite Dog the Bounty Hunter, but I've seen things that are not terribly far off. So that is the short answer is yes. There are also some judges will impose an unsecured appearance bond, which is essentially I promise to come back to court, and if I don't come back to court, I'm going to owe you $25,000. The judges that do that are fairly rare, but those judges really take the economic circumstances of the individual into account and think you shouldn't be in jail because you can't come up with the money necessary to get out of jail. And that's in their discretion to do that. Okay. Owen, did I see a hand?
Yeah. My question is, so we have this example of someone who has multiple drug arrests, for example, and the catch and release is happening. So there's the one arrest, they're released, the next arrest is also another drug possession or drug sale. Why is that possession of a substance not a violation of their conditions of release, which would put them back in jail?
So in the past, it almost certainly would be. Yep. Why if someone is out on bail for drug possession, if they get a subsequent drug possession, why is that not a violation of conditions of release that would allow the court to impose additional bail, or potentially, depending on the circumstances, to hold them without bail? The judiciary recently produced a document that is the sort of model conditions of release. It was revised through a committee, I want to say like a year and a half ago, and they intentionally struck the purchase, possess, or consume regulated drugs without a prescription condition because of the reason that I mentioned earlier, that it's incredibly problematic for people who have significant substance abuse issues or substance abuse dependency to just suddenly have this condition where they're not allowed to, where it's a hard stop on that. Certain prosecutors' offices will still request it. The Windsor County Prosecutor's Office still requests it on a regular basis, and it's still imposed on a regular basis. I think there's a tendency, both within the judiciary as well as within the bar, to not want to put people in jail for that reason, for having serious substance abuse issues and not being able to quit cold turkey. I think a lot of us have recognized that it's a serious public health crisis. That it's a serious public health crisis, and as a result, have come to the conclusion that while there may be reasons to put people in jail, that's probably not a great one. Yes?
Not to get into a particular case with you, but I'm just curious. Our neighborhood drug dealer has been in jail now for quite a while. Is he getting help?
Are you in East Bethel?
No, North Main.
Okay.
Because you said that about
Mhm.
I mean, he's been off the streets now for quite a while, and it's such a nice, quiet neighborhood now, but I still worry about it. And wonder, is there anything good happening for him?
So essentially, the question is whether or not there's drug programming in the Department of Corrections facilities. Not meaningfully. There is medically assisted treatment, so they have access. If they're already on methadone, they have access to methadone, and that's actually cannot be administered on site, so they have to be transported to a methadone clinic. If they were not previously on methadone, they have the ability to get Suboxone. And medically assisted treatment essentially just, does anybody not know what medically assisted treatment is? I see no hands. Okay, then I won't waste time on it. So they have the ability to get medically assisted treatment. There is Narcotics Anonymous and Alcoholics Anonymous in the facilities, but there's not meaningful drug counseling.
And this is kind of a little off topic too. How easy is it to get the drugs in jail?
Tough telling, not knowing. The question was, how easy is it to get the drugs in jail? I think I've seen one case get charged of somebody actually getting caught transporting drugs into the jail. It's not a super common charge. It is a crime, but it's not super common. I don't know how much of that is them just not catching people. So I don't know the answer to that. Yes?
Is there a statutory definition of habitual offender?
Yes.
And how will those adjudicated? Did they go through the whole process again?
So the question was, is there a statutory definition of habitual offender? And how does that get adjudicated? Do they have to go through the whole process of essentially convicting them of those prior felonies again? The answer is the statutory definition is if you're charged with a felony, having 4 prior felony convictions within any state that would qualify as a felony in the state of Vermont. That's my understanding of it. I haven't looked at that statutory framework in a little while, but that's my understanding of it. They do not have to go through adjudicating each one of those offenses again. They can get a certified copy of the conviction and enter that into evidence. Usually, if that's going to be an issue at a trial, the parties will stipulate to it because you don't want the jury hearing that your guy has 4 prior felony convictions. Okay? All right. Moving on to how long cases take. Not as long as it takes me to talk about the criminal justice system. So generally speaking, in misdemeanor cases, you're looking at an expedited process. Some misdemeanor cases are complicated, and DUI cases are deceptively complicated. But most misdemeanor cases in Windsor County, because we've worked really hard to get through the backlog, you're going to have a pretrial conference somewhere between 60 or 90 days. That's going to be your first hearing. In the process, the defendant, if they're appointed a defense attorney, will request what's called discovery from the state, which is, give me everything you got about this case, everything I need to know. And you have a due process right to that discovery. And one of Owen's questions was, what is due process? We hear a lot about it. What does it mean? So due process is essentially, the United States Supreme Court has interpreted it as a two-pronged approach. First one's pretty apparent, which is what's called procedural due process, which means the things that were supposed to happen while the case was going on actually happened. One of those is, if you're eligible for a public defender, you get appointed a public defender. You had the right to counsel. You had the right to a trial by a jury of your peers. You had the right to get the discovery from the state because you have the right to know what the charges against you are. There's actually a provision in the Vermont Constitution that explicitly says that the defendant has the right to call for the evidence against them. And the prosecutor is legally required to provide that evidence. It's been in the Constitution since the beginning. The due process right in the United States Constitution does not explicitly say that. The Vermont Constitution does. So that's a cool thing about the Vermont Constitution. The due process right is established by the Fifth Amendment to the United States Constitution, which applies to the federal government, as well as the 14th Amendment to the United States Constitution, which was one of the Reconstruction constitutions or constitutional amendments after the Civil War, at which point the federal government said, hey, states, we suspect you probably are not providing people with due process of law, and we suspect that you might not do that in the future. So the federal constitution now includes protections against state actors in terms of due process. First prong of due process is that everything that was supposed to happen during the case actually happened, had the right to a trial, had the right to see a judge, had the right to do all the things that are provided for in the procedure. Second thing is what's called substantive due process, which is more nebulous. It was created by the United States Supreme Court. Essentially, it stands for the proposition that all people get the same protections under the law, and that certain fundamental rights that are provided to us under the Constitution require a higher level of scrutiny in order for the federal government or the state governments to infringe upon those rights. So freedom of speech being an example, there's a clear liberty interest, and the court has said that you have to meet a very high burden in order to infringe on someone's freedom of speech. So that's what due process means, are those two things. Everything happened the way it was supposed to happen, and everybody's treated equally, as well as fundamental rights receive additional protections.
Does the second one apply to a person who is not a U.S. citizen?
Does the second one apply to a person who is not a U.S. citizen? Yes. Substantive due process does apply to a person who is not a U.S. citizen. They are not necessarily a protected class. So what that means is that in order to legislate, and again, immigration is controlled by the federal government, not the state government, but in order to legislate that, they are not necessarily protected. They don't necessarily receive a higher level of scrutiny due to the fact that they are non-citizens. Okay, so that's the due process. We're still talking, believe it or not, about how long a case takes. So the prosecutor provides all the information that's necessary in order for the defense attorney to defend the case, and then the defense attorney will analyze that, meet with the client. They are required ethically to do that, to meet with the client regularly and provide them with updates in terms of what the case is happening in the case. In a misdemeanor case, the first hearing will usually be a pretrial conference in Windsor County. Previously in Windsor County, there was a hearing called a calendar call that was totally useless. Essentially, it was an opportunity for the parties to come together and see if they could reach an agreement. And almost always, the parties came together. Nobody had gone through their discovery yet. And they talk about what the next thing that should happen is, and they kick the can down the road. So the court, I don't know if you all know, the White River Junction Courthouse is under construction right now. When the court moved to Woodstock, the court decided that they did not have the court time to provide for that useless hearing. And oftentimes, criminal defendants who didn't show up were getting a warrant for not showing up to this useless hearing where they didn't even show up before a judge. So the court decided to no longer do that and simply set pretrial conferences. Pretrial conference is essentially a status conference before the court where you tell the court one of three things. Either we have a plea agreement, this is going to be a trial, or we need more time. That is usually going to be anywhere from 60 to 90 days. The court will weigh its calendar to determine whether or not, if you ask for a trial, whether or not they're going to have enough time to try that case on that particular day. Windsor County, there's almost always more court time than they need. A relatively few number of cases go to trial in Windsor County. Those that do are usually serious cases that can't be worked out by the parties because there's simply no factual agreement in terms of what happened in the case. Which, that's why a trial exists. So that's in terms of misdemeanors. Felony cases, there's going to be a status conference in about 60 days. And at that status conference, the parties are going to work out what's called a felony scheduling order, at which it's going to set deadlines for how things are going to happen in the case. There's a due process right in the state of Vermont to depositions in felony cases. So you can put every single witness in the case under oath, ask them questions about the case, and find out what's going to come out at trial in a felony case. Limited right to depositions in misdemeanor cases doesn't necessarily happen very often in misdemeanor cases. But in felony cases, the defendants get that as a matter of right. So usually the felony cases will take somewhere around 6 months if it's an uncomplicated felony, simply for that process to play out. Then after that, for more complicated cases, they could drag on for years. Things like homicide, sexual assaults could be years in the making in terms of the case. And again, as I said, it could be years in terms of the investigation leading up to the charge. So you could be looking at 5 years before the case concludes. Fairly rare, but that does happen. And then once you get to the pretrial conference, again, you're making a determination which one of those three things you're going to do. And you're maybe getting up in front of a jury and picking a jury. So that'll be the next section. Anybody got any questions about how long a case takes and what happens while the case is pending?
Do towns have reports on their cases? I mean, do they have a reporting report?
So I'm sorry, I'm just trying to mute my phone because it keeps going off. Some towns have a police blog, essentially, and there's the Vermont State Police have a press release website that their mugshots are posted as well as the nature of the charges against them. Most towns that I'm aware of don't have any other sort of reporting source other than a newspaper in terms of what's going on with pending cases. I'm not aware of any.
We have about 15 minutes left.
Yeah, so we're going to speed through trial real fast. The most interesting part. First is jury selection. Normally, I don't know if anybody here has ever received a jury summons and had to show up for jury duty. Have I picked a jury with anybody here? So jury selection, essentially, they put usually between 36 and 48 people into rows in front of the jury box. The attorneys get the opportunity to ask them all sorts of invasive questions about their biases and their prejudices and their own personal life stories. Most attorneys try and build a rapport with the jurors as well by joking around and having fun. I'm not sure that that's necessarily appropriate, but I've been known to do it from time to time. And eventually it's whittled down usually to a jury of 14. That'll be 12 jurors with 2 alternates. Those 2 alternates will be determined at the end of the trial. So in the life offense cases, so those were Owen's cases, the life offense cases, there's a right to go to trial the business day following picking a jury. It's called a pick and go. So jury gets seated, next day we're given opening statements. Opening statements are essentially an opportunity to present to the jury what the evidence that's going to be presented to them is going to look like. It's not the opportunity to argue the facts of the case to the jury. That's during closing statements. Both sides are given the opportunity to present cases through witnesses. Both sides are given the opportunity for cross-examination of witnesses, which is through yes or no questions, leading questions, if you're good at what you're doing. And then the state bears the burden to prove the case beyond a reasonable doubt, each and every element of the offense beyond a reasonable doubt, and the jury verdict has to be unanimous. Both sides have the opportunity for a bench trial, but the parties have to agree, and a bench trial is just a trial before one judge rather than a jury. The only time that I'm not going to get into the calculus as to why I did it, but there was a client who I had who had significant possible issues in front of the jury that I knew the judge was going to acquit because the facts were going to present themselves that way. So it's a tactical decision in a lot of ways. No, not in a criminal case. In certain contexts, in civil cases, I believe it can be by majority. Haven't had a civil trial yet, though. Because, well, I just moved to a civil defense firm, so that day's coming soon. And then obviously if a person is convicted, if a person is acquitted, they're acquitted. Unless there's a legal issue, no, if a person is acquitted, they're free to go, charge can never come back for double jeopardy reasons. If a person is convicted, then they have the right to appeal to the Vermont Supreme Court on any issue that's preserved below, meaning it has to be an issue that was raised and argued at the trial court level. And then the Vermont Supreme Court gets to make a decision by a majority, not by the full bench. All right, questions about trials?
How many, just your guess, what's the percentage of convictions by plea versus a trial in Vermont?
Convictions by plea probably make up 95 plus % of cases.
So trials are very rare.
Trials are very, very rare.
Someone is convicted of, I assume, a misdemeanor. What is the process by which that conviction can be expunged if it can? And how often does that happen?
So the expungement statutes are fairly clunky. They require, there are sort of tiers of analysis involving whether or not a person's been convicted of a subsequent crime. There are only certain qualifying offenses that qualify for expungement. And so it's a more complicated question than I think we probably have time for at this point, given my proclivity to talk and talk. Any other questions about trial? Yes.
I was curious about the jury thing. I got called once in my lifetime. Didn't have to serve on a jury, but I got called, play cards and stuff. My husband's never been called. I was talking to a friend last week who has done jury duty 4 times. How does this happen?
I don't know. I don't know. The judiciary makes up a list somehow. So, yeah, I don't have a good answer for that one. The question was, how does the jury pool get created? And I don't know the answer.
In my mother's day, women were allowed to refuse jury duty because they were a woman. Is that still an acceptable message? Not so.
The question is, can you refuse jury duty because you're a woman? The answer is no. Both the defendant as well as the juror themselves have a right to a representation of their community. And I think that probably would put a thumb on the scale in terms of the composition of the jury itself. So no. Convicted felons in the state of Vermont are not allowed to serve on a jury. And I believe you need to be a United States citizen to serve on a jury in the state of Vermont. So those would be the limitations that I'm aware of. Gene?
When I was in Ohio,
Mm-hmm.
I was not being forced to be a juror, but I could choose to serve if I was.
The question is whether or not clergy are required to serve. I'm not aware of any exception for clergy. I don't know the answer 100%. I'm going to tell you, if you show up for jury duty, I'm not picking you. But that being said, yeah. Owen.
Does anything about what you just described for the whole criminal process change for someone that can afford an attorney versus someone that's being appointed an attorney?
The question is whether or not the criminal process itself changes depending on whether or not you are appointed an attorney by the court, also known as a public defender, or whether you hire a private attorney. The process does not change. The ethical obligations of your attorney do not change. What I will tell you is that the duty of competency and diligence in terms of the professional responsibility is reflective of what your caseload looks like. So you would be owed the professional competency and diligency of a public defender versus a private defense attorney. Those aren't my words. Those are the words of ethics counsel, now retired ethics counsel. So you may not get as many phone calls from your attorney. You may not get written status updates as much if you get a public defender, but they are required to work on your case just as hard, and you're required to get the same level of representation. That is the professional standard of conduct.
But like, what if someone being charged with a crime, be making financial decisions potentially, like up until trial, it's going to cost this much. If I decide to go to trial, I'm paying for hours, for example. So there might be another outlet in that person's mind when making those choices.
The question is whether or not financial decisions involved in private defense practice may cause a person who has hired private counsel to be less likely to move forward with a jury trial because of the additional cost. Sure. Yeah, absolutely. You're looking at a jury trial. When I was still doing almost exclusively criminal defense, I billed at a little over $200 an hour. And you're looking at days and days of time for a serious felony case, and if not weeks of time to prepare for that. So you're talking 5 figures to go to trial.
What's the bar for qualification for public defense?
You're going to make me remember numbers. So first of all, it has to be an offense that the state is seeking a punishment that is either involves incarceration or more than $1,000 fine. Otherwise, you don't qualify under the Public Defender Act. Some judges will still appoint if there are interesting legal issues because they think I can't say no. So some judges will still appoint. I want to say it's like 75% of the federal poverty. No, I think it's like 125% of the federal poverty line is the qualification for public defender services. There's what purports to be an affidavit that people who are applying for public defender services have to fill out. It's not an affidavit. They don't swear to it. It's not an affidavit under the law. Leave it to the judiciary to screw that up. But yeah, so they fill out this application, and a judicial law clerk essentially makes a determination whether or not they qualify for public defender services. All right, last thing, and I'll let you out of here. I'm happy to stay after and talk out on the curb if we need to, is sentencing. So the last thing that'll happen in terms of a criminal case is a person will be sentenced to an offense if they're convicted. That sentence can take a few different forms. First is a fine. Y'all get that. Just because someone gets a fine doesn't mean that there aren't other potential collateral consequences of a conviction. A lot of those look like things like if you're convicted of a DUI, your license gets suspended. If you're convicted of a domestic assault, you lose your ability to own or possess firearms for the rest of your life. So that's category number one. Also, if you're an undocumented immigrant, or if you're someone who's on certain statuses, being convicted of a crime could involve deportation, which is what we're seeing in some cases, although obviously not all cases. So those are all things that could be associated even with a fine. Next sort of bucket of sentences are suspended sentences. So those are sentences where a person's sentenced to probation. By far and away, the most common sentence in Windsor County is a probationary sentence. That means that someone's placed on conditions by the judge. That person has a probation officer who's going to have some amount of supervision over them. Usually it depends on the person's criminal background as well as the nature of the offense that they've been convicted of. For a set period of time, they're going to be on that probation. And by statute, certain offenses, if they do everything that they're required to do, can get off at the halfway point if they've done everything that they need to do. Incentivizes people doing what they're supposed to do, and obviously lightens the caseload in terms of the Department of Corrections. They're placed on conditions and out there in the public. If they violate their probation, they come back to court. There's not a presumption necessarily of them getting out, depending on what they were convicted of. jail. So the commissioners. There will be an underlying sentence that's so opposed to the judge is required to arrange people from, if they're in the facility, to do the things they need to do. So in that example of 1 to 3 years, that person could spend 1 year in jail and then be eligible to get out on the street. Or they could, or if they're staffed, and by that I mean analyzed by trained Department of Corrections caseworkers to present a significant risk on the street, then they could end up in there for 3 years. So the Department of Corrections has a whole lot of discretion in terms of those cases. There's a program called furlough, in which you're technically still serving a jail sentence, but you're on the street. And there's parole, which people are probably more familiar, which you're still serving a sentence, but you're on the street. Either way, you're subject to no court proceedings if you're picked up on a violation. They take you off to jail. You're sitting there until someone makes the decision to release you again. And so those are the 3 buckets of incarcerative sentences. Anybody have any questions about those? All right, that was pretty thorough. I'm happy to answer any additional questions anybody may have.
You have a question?
I do.
Dave.
Part of what I read tonight was, what can I do to protect myself? I'm
Yes.
I live alone.
Yep.
It's not the only one here.
Yep.
And I live very close to seniors. Right on.
Yep.
So, what can I do to make sure that I'm not harmed?
Worker, are you still recording?
Sign us in.
So the question was, self-defense, what can you do so that you're not harmed? There's 2 different categories in terms of this. There's defense of a human being, whether it be yourself or others, and there's defense of property. So either way, it's judged on the reasonable person standard. For I know at least one other person who attended law school here. The term reasonable does way too much work in the law. And so the reasonable person standard is what self-defense is judged by. There is no duty to retreat in the state of Vermont, but there is a duty to only administer the amount of force that's reasonable to protect yourself or protect your property or protect others. There's also a defense of others defense. So in defense of a human being case, you're allowed to administer lethal force if it's the force that's necessary to defend a human being. Lethal force or potentially lethal force. If it's defense of property, and unfortunately that includes animals in the state of Vermont, you are not allowed to use lethal force in the defense of property. I wish I could give you a more clear-cut answer, but I think realistically speaking, in terms of defense cases, it will almost always be a jury issue. So a jury's going to have to make the determination whether or not you use the amount of force reasonable under the totality of circumstances in the situation. That's the best answer I can give you.
So if someone is coming into my home
Mhm.
to harm me or rob me, or I can take anything, you come through the door.
Mhm.
I'm shooting away.
You can use the amount of force that's reasonable under the circumstances. And
Stop them. Why don't you come back
And that means that if somebody's coming towards you and you are in a reasonable fear for your life, Orca, you can shoot that person, in my opinion. If you are in a reasonable fear for your life or the life of others, you can shoot that person. But a jury's going to determine whether or not that was reasonable.
But if I'm there alone, like you're saying, that's pretty reasonable, me, to defend myself at night or whatever.
I've seen people in my yard.
Yep.
They didn't come to the door, thank God.
Yep.
But in every case, like the
I'm not aware of any case, we didn't even talk about motion practice. I'm not aware of any case where a motion to dismiss was granted on the grounds of defense of self or defense of others. It will almost always be a trial and be a question for the jury. Now, in the process of plea negotiations, the prosecutor is going to take that in mind. And the prosecutor may take it in mind in the decision whether or not to charge the offense in the first place. But I think it's always a jury trial. There's no clearly established standard in Vermont that I'm aware of as to what amount of force is necessary. It's just the word reasonable, you doing a ton of work. Gene.
Pointing the weapon at a person is a show of force.
Yep.
And then the person comes at you. That's the difference.
Yep. I mean, if you point a weapon at someone, that is a display of force. It's a show of force. And if that person continues towards you, I would say it's a reasonable. Okay. Well, then I gave you the answer you were looking for.
based on interpretation, based on the sanity of the individual and circumstance.
Well, sanity is also a legal standard that we didn't get into, but there really isn't. So they're both affirmative defenses, meaning things that the state needs to disprove by a preponderance of the evidence. Some prosecutors will tell you that the defense needs to prove it, but that's not the case. The state needs to prove it by a preponderance of the evidence. And it's going to be up to the jury to make a determination. All right.
Thank you.
You're welcome.
Thank you.
Thanks everybody for coming out.
Thank you.
Feel free to take a couple more snackies. There's a bag over here for recyclables and there's trash out here. The bathroom is right outside of you.
Always be our mayor.